Hello everyone, Derek Johnson with Tatango.com. We're doing a TCPA text message marketing case review today with Joe Bowser from the TCPA Defense Force, which is part of Innovista Law. We've done a few videos with Joe in the past. Hey Joe, how are you doing?
Doing well, Derek. How are you? Good,
man. Good. Okay, so today's TCPA case review is, and I bet I'm butchering this name, but Serban, S-E-R-B-A-N, versus Cargurus Incorporated. So, and maybe Serban, I don't know. So this was actually, that's a person, correct? The first one?
Yes, she's an individual. That's right.
Okay, perfect. So that's their name. So a person suing a brand for a TCPA violation. TCPA stands for Telephone Consumer Protection Act. So let's review this here. I've written some notes, and then you can jump in and kind of fill in maybe some of the remaining blanks here. So sure. A user, so this is this woman, of the defendant's site, which was Cargurus. So Cargurus has a website, and someone mistyped the woman's phone number, telephone number, mobile phone number, into Cargurus' website. Now, the reason Cargurus had people type in their phone numbers, at least according to this case, is they had a send to phone option, which was essentially if you saw a car on the website, the cargurus.com, you saw a car and you were like, ooh, this would be really cool or interesting, or maybe location about where the car is or price or something like that. Sure. I would go to the website and I would go, oh, that's interesting. I want to send that to my phone because maybe I want to go find that car. Maybe I want to go find that place. So somebody,
or you want to send it to your boyfriend, your spouse, whomever.
Okay, right? Interesting. Yeah, that's another good kind of use case for that. Is so somebody went on that with, I would guess, kind of good intentions, and they, typed in their phone number, what they thought to be their phone number, and maybe they fat fingered, which is what my dad always says, is essentially mistyping the phone number into the form field and clicking, send this to my phone, but actually it was sending to someone else's phone.
Right. Our English teachers would call it transposing the numbers.
Okay, you guys always use big. You guys always use big words. I'm more fat fingered.
I like fat finger too.
Okay, so, and we don't know if this was, this was maliciously done, because I could guess you could do this. You could go to their website and type in your friends' phone numbers and just spam them with text messages.
Sure.
It seems like, reading the case, this was just somebody that mistyped their phone number and the message went to somebody else.
Yeah, all indications were that there was a legitimate user of Cargurus' site. They texted themselves 10 different or 11 different, car texts, and those were sent, without incident. And then, as you said, a 5 and a 0 were transposed. They texted 5505 instead of 5055. So it does look like the quintessential fat finger case, to use the expression.
A really good point, and this is why I love having you guys. You guys get really into the details of these cases. I didn't even know that. That's a really interesting point, that you were able to figure that out, or the Cargurus, I guess, was able to figure that out because they kept good records of all the text messages that were sent. Now, on another
they should.
Yeah, exactly. You said on another TCPA case review, that the statutes of limitations are how many years?
4 years. 4 years for the TCPA.
Okay, so
you don't know when they're going to sue. You don't know when they're going to sue. So you want to make sure that so they have 4 years to even bring the case.
Okay.
So you don't want records falling off just because they're 4 years old. So she may sue 4 years hence, and that would be fine. That would be within the limitations period. But if you've got to go back and you've been sending her messages for a year, you really need a 5-year window, for that period. So long as you're texting someone, you want to keep data related to that particular campaign and or that user for as long as you're texting them +4, because it's on us, the platform provider or the brand, whomever the defendant is, to show consent. It's a so-called affirmative defense, meaning the defendant has the burden of proving it. She just has to say, I didn't consent, and she's off to the races. She's got a case, and it's up to us, the defendants, to show that she really did consent.
So this would be a good example as well. Obviously keep your SMS records forever. Also, every record, inbound, outbound. In this case, they kept all records, the 9, that were successful and 1 maybe that went to somebody else, keep them all because this can help, in these type of situations is figuring out, what the consumer did previously, what they did after, really have a full record.
And the other thing you want to do is make sure so the engineers and data folks will often just keep the databases.
Okay.
You want to make sure that the marketing team keeps screenshots of what the website looked like or the platform looked like at any given time, because it's much more powerful to be able to show the user's experience than just getting the CTO up, on the stand or in an affidavit saying, here are the records that are pulled from our database. Here's how we maintain these records. It's all fine and good, but if you can put a picture to it, a lot of the judges don't do this every day. They're not familiar with the process. And if you can throw up a website and say, here's how the user experience flowed for these folks, and here's what we keep on the back end, and that's where we got the data, they can picture in their mind much more easily, okay, I get it. That looks like consent to me. Where if you just see rows on a database,
it's a little, it's
you're not keeping anybody interested, judge, jury, whomever you need to persuade. And so I always get the marketing folks to hang on to the copy of whatever that UX was like.
Okay, so let's make a call to action right now for anybody watching this. If you have, a website that is accepting phone numbers, like a website form, you have a billboard, in-store advertisement, take a photo, take a screenshot, store it in your Google Cloud or wherever you store your important information, and just keep it there. And if it changes, update it.
And make notes of when it was live.
Okay, perfect. And also another good thing is I see this happen a lot, especially with these kind of send a phone type things, is possibly this program was a pilot, which means that maybe they try for 6 months and it doesn't work, or they decide to go to another provider. Just because the pilot didn't work, let's say, or because maybe they decide not to do it or they went, with somebody else, that doesn't mean you can just cancel, your subscription to your SMS, marketing service and, lose all that information. Download all that information before you stop the pilot so that you have that information, because 4 years down the road, you could be faced with some kind of lawsuit that you have to defend.
Yeah, I mean, I have definitely had more than one call where clients, call in and say, hey, we started this pilot. Then I saw your website or I saw something else in the news or, in the trade press, and we're pretty convinced we weren't doing it right. And we flushed it all. It's like,
because then you don't have at least a defense,
right.
Okay.
Yeah. So then you really are just 2 hands behind your back.
Yeah.
And you're just going to take your lumps.
Okay. So always keep the records. So I guess what it comes down to here, which this is kind of a interesting topic, because I think when I go to, let's say, a dinner with friends and they have received, let's hypothetically say they received a message from Cargurus that had a Ford Focus or something, at some car dealership, and here was the price, and they received a text message from Cargurus with a Ford Focus that they never asked for. They don't know who Cargurus is. That seems like text message spam to me, because I did not ask for it. But in this case, because the TCPA essentially kind of has consequences for text message spam. What happened in this case? Because it seems like the court said that wasn't text message spam.
Well, the court didn't exactly say that. I'll put a finer point on it. The court didn't deny that it might be spam.
Okay.
But the TCPA only holds liable the sender of the message. So the case was really about, did Cargurus send the message, or did Mr. or Mrs. Enos here, the person who sent the first successful 10 messages to the 5055 number instead of the plaintiff's 5505 number? So to be liable under the TCPA, excuse me, you've got to be the sender of the call. So they use various verbs: send, initiate, or make a call. So you've got to be that active person behind the button hitting, send on the phone, send on the SMS. And so TCPA liability attaches to that person or company. Now, there may be more than one person who is the sender, because if brand X hires a marketing agency or hires me to craft the campaign and send it for them, I'm essentially acting as their agent.
Okay.
And so we both can be on the hook as the sender. That's a concept of vicarious liability. But the case in the Cargurus case asked whether is Cargurus the sender of that message.
Okay,
it was probably spam
because they were being sued. So essentially, Cargurus was saying, I know it came from us, but we didn't actually click send. Therefore, we shouldn't be sued for the text message spam. Maybe everybody agrees that's unwanted text messages. I think I would agree that that's unwanted from the consumer. But under the law, an unwanted text message, you have to sue who sent the message, not the middle party, which in this case, because it's not a mass text message, it was somebody that went and typed in their own phone number and clicked enter, they typed in somebody else's phone number. Right. They're saying not our problem.
That's correct.
Okay.
And the court was really focused on where should TCPA liability exist in this fact pattern. And so they lined up
to, would they say not my problem? It's the person that clicked send, like that individual consumer. Could she be sued for violating the TCPA?
She could. I don't know that you'll find a lawyer to take that case because it's only worth $500 or $1,500. There's no indication that it was an intentional violation. So at best, you have a $500 case.
Oh, yes.
And the plaintiff's attorneys probably have something better to do.
And explain that. And I remember this. Usually people throw out the $500 to $1,500 per text message for violating the TCPA. Explain for $500, what are the qualifications compared to $1,500?
So most courts treat the TCPA as what's called a strict liability statute, which means you don't have to prove that you tried to violate the law.
Okay.
Right? If you don't see a stop sign and you run it, you still get a ticket, right? Because the cop doesn't care that the tree was hanging over the stop sign. It's a strict liability law.
Okay.
You don't look into fault or anything like that. You look at the conduct. Did the conduct violate the law? If you're supposed to stop at a stop sign, who cares if you couldn't see it? Sure, they should cut the bush back, but you're on the hook because you really did cross into the intersection. So too with the TCPA. They don't really care if you tried to violate it or not. That only has consequences for what damages are owed. So negligent violations of the law, $500 per call or text. Intentional acts, like I really did try to send that message. I thought I had consent. Turns out I didn't. Now you're talking $1,500 per call or text.
Okay, so in this case, and the reason most likely this other consumer is not going to sue this other consumer is it was one text message, and that most likely that consumer doesn't have the kind of insurance and deep pockets that a Cargurus has. Most people go after the people with the biggest pockets, and if it's too small pockets, just not even worth their time.
Well, right, and good luck finding them. And there are very few, if any, to my knowledge, cases against a fat-fingering defendant. It's just not the kind of liability that Congress contemplated.
Okay.
Right. So courts put a kind of common sense backstop against it to say, hold on now, like this is not what Congress had in mind. They really were thinking about people who were interrupting dinner and engaging in an actual spam.
Yeah. Okay. Now,
well, you can get technical, but
true. Yeah.
one message, I'm pretty sure the court would give you a pass.
Okay. Now, let's be clear here. This was what we call a single, it seems like it was, a single message program where the phone number was typed in and they got a single message based off the person typing it in once and clicking send, and they got one message. They typed it in again, they got one message. Like, it's not I typed in the phone number and I opted in for recurring text messages. This was a send to phone, and we see this a lot with like app downloads. So you go to a popular app website and they're like, hey, download our app, type in your phone number, we'll send you a link to download the app. And essentially they're saying in this case is that, if you get a text message that actually a person went and typed in the phone number. Now, let's say the app company, they just get, a million phone numbers randomly, they data mine or something like that, and they send a mass message to all of those people with a link to download their app. That would be a violation because there wasn't human intervention. It wasn't a single person typing in a message or their phone number, correct?
Right, and there's a famous FCC case about that called the Glide app case,
oh, yes.
where Glide did just that. They mined your contact list and automatically, without the user's consent, sent all the people on your contacts a link to download the Glide app. Okay. And so that is the poster child for the way not to do
and
text messages.
More on this mass text messaging side. So I think SMS marketers, because we do get this concern a lot, because it makes sense, is somebody like an app company or a send a phone like a car place or those type of operations, they will put some type of form on their website and they'll go, well, what if somebody types in somebody else's phone number? And I think in this case, it says, look, it won't be your responsibility. Again, you might have to go to court, and that's why you keep the records, but it won't be your responsibility, the website owner. It would be the person that actually entered the phone number into the form.
That's right.
Okay.
Because they're deemed the sender in these fact patterns where you're choosing those operative elements of when do I send it, to whom do I send it, do I send it at all?
That's the consumer, not the app company that's just a dumb website just waiting for somebody to type in a phone number to send an app download link.
Right, because presumably the user who was actually trying to send themselves the link to this 2006 Jaguar XK, they could have emailed themselves the link or whatever, right?
Okay,
but they're at the wheel, right? Okay. They're steering, they're choosing whether to send the messages, when to send them, what about, right? They pick the car. Yeah. It's not like Cargurus said, would you like this Fiesta?
Yeah. Okay. So this also brings up a really good point, kind of tangent, in one of the, I think, most heated topics in SMS marketing for kind of the people, brands, and then people like myself, is the concept of double opt-in for recurring text messaging campaigns. So a recurring text message campaign is when people opt in to receive multiple future text messages. So like coupons weekly from your favorite restaurant or your retail store. So what we get asked a lot is, well, what if we have, let's say, we are a brand and we have a website, and we have a form on that website for people to put in their phone numbers not to send a phone one-off messages. This is to opt in to our SMS database, which we're going to use and send mass messages every week. So usually what they say is, okay, type in, phone number into the form, click enter, click subscribe or whatever it is. And then back in the day, it used to be, I think before kind of people started getting educated, the consumer would get their phone and they would get a text message and it would say, thank you for joining our mass text messaging list. We'll be in touch with you soon.
Right. Expect so and so many messages a week or month.
Yes.
Help to help, stop to stop.
So the issue with that is we've just seen here that people fat finger forms. Now, maybe intentionally, maybe unintentionally. Now, if someone, because of that fact that people, this is common and it happens all the time, if that is the case, then you are opting in somebody that actually didn't type in their own phone number, and then the future text messages to that person, the automated text messages, the mass text messages with a coupon, every single one would be a violation of the TCPA, right?
It would. It would.
Okay. So that's why we always recommend at Tatango doing a double opt-in. And the double
where you get that second yes.
Yes, because
go ahead.
the first, so when you do a double opt-in, you would type in the phone number into the brand's website, you'd get a text message. At that point, you're still not subscribed to their list, and it would say, please reply yes to consent to the conditions of terms and auto dialing and all the stuff that needs to be included. They reply yes, and then they're opted in. Are you saying that essentially the TCPA in the courts right now, that original reply yes would not be a violation of the TCPA, even if it was received by somebody that didn't type in their phone number, somebody fat fingered their phone number into that form?
Well, it could be if it's a telemarketing message, or even if it's an auto-dialed message.
Okay.
Then arguably even that message could be in the same way that the Cargurus text message was a technical violation of the act, because it was unsolicited, probably sent via an auto dialer, and there you go. You've got liability.
Okay. So that's good to know. So there is kind of a violation there. But I think what is interesting is the person that is the violator, I guess, would be the person that typed the phone number into the form, not the brand.
Assuming that's the fact pattern, right? Because you know, like circumstances where there's a retail shop and they've got the list to say, join our SMS campaign. So then it's your employee who's entering it into the database, and there they can fat finger.
Okay, and that would be a different case because they would be employed by the big brand with the big pockets. But right. If it's let's say a consumer-facing website, and somebody literally just types in the wrong phone number, at least that first initial message is, would presumably be the liability of the person that actually put in the phone number into that form. And then that's why you always make them reply yes to that message, because if they don't reply yes, then there really is not that much of a case there. But if you skip the double opt-in and you do a single opt-in, which essentially phone number goes into form and then goes into the list,
and they start getting the drip of messages, right?
Then, 100 text messages later, it could be $100 times anywhere from $500 to $1,500 per consumer. And then let's say you had, 1 million consumers in that class case. This could be $1 billion lawsuit.
Easily.
Okay.
Easily. That's the screen between you and bankruptcy.
Yeah. Okay.
So even if it's not required by the TCPA, it is absolutely good practice to do the double opt-in, to get that yes.
Yeah, because have a record of it in SMS, right? Because you would, instead of, just something like, hey, they hit the website, this would be, I have them getting the text message and then replying yes, and I've kept those records.
Right, because what you get with the professional plaintiffs of the world, when they hit that website, you might get an IP address, but good luck tying that IP address back to the plaintiff, because they might be going to the public library, they might be using a Tor, right? Yeah. Like if they want to cook up a claim, they're not going to go home
and make it easy.
Use their home IP address, because then you could really tie it to them with a little bit of discovery and investigative work. So you want to get that yes from that phone number.
Yep. So it seems like in this case, just to kind of summarize, is essentially. I think and most people would agree that was text message spam. It was unwanted. It was annoying. That is true. The responsibility of that message under the TCPA, they thought it was Cargurus because it was Cargurus' website. The message even said Cargurus and it had all their info. Sure. What was, resolved in this case, I guess, was it is not Cargurus' responsibility. It was the person that actually typed in their phone number into the website.
Exactly.
Okay.
Exactly.
Interesting.
Yep. And the court used 3 FCC cases, 2 that came out on the side of the platform provider not being the sender, or the app developer, whatever the technology was. It wasn't terribly relevant to the case on the one hand, and that Glide case that I mentioned earlier. So in Glide made all of the operative decisions: who to send it to, when to send it, what to say, and whether to send it at all. Right. Okay. Glide answered all of those questions. So there, Glide's the sender. In the other FCC cases that the courts have been using as the 2 goalposts for figuring out who the sender is, when you have users on the one hand and technology providers on the other, those apps or websites, as the case may be, they did not decide who got the message. They let the user decide which of their contacts got the message. They might have participated in crafting the content,
like
to say, hey,
them.
Johnny would like you to download this app, join him on this app. So there was in one of the cases some pre-crafted text that they could choose to send, but it's no different than the letter to the congressman that the congressman prepares for you and you sign, but you're choosing to sign, right?
Yes, yeah.
You're choosing whether to sign it, when to send it, etc. So there you're picking who gets it, when do they get it? Do they get it at all? And in those cases, when the platform provider or the technology provider didn't decide those key questions and the user did, the user is the sender and not the technology provider. But if the technology provider usurps your choice in all of those key questions, then the courts are going to treat you like the sender.
Yes. Okay. And in this case, for Cargurus, luckily for them, they were not considered the sender. And most likely this is not going anywhere because this consumer is not going to most likely sue another consumer, for $500.
it would seem unlikely,
Yeah.
and we probably wouldn't hear about it. Right?
Yeah, exactly. Okay. I know you guys have a ton of resources and a really great blog. Where can they find those resources?
You can find us at tcpadefenseforce.com. tcpadefenseforce.com.
Okay, and you guys have a really good blog, so sign up for the emails because you guys are up to date.
Right, industry-specific e-guides and exemption guides, and meatier e-books where if you're focused on the litigation aspects or the rules aspects. So whatever your TCPA needs, we've got tons of free content on there that will hopefully familiarize yourselves with the key contours of the TCPA. So help yourself.
And that's something to make sure these videos, we do them to educate. Maybe to entertain a little bit, if somebody is so interested in TCPA like I am. But really, at the end of the day, it's more of to give you a background, to ask the right questions, to double check things, but always have your own third party or own counsel, TCPA counsel, like you, a TCPA attorney, to review things, to actually look at a case and go, does this apply to what we're doing? Because YouTube videos are great, but always rely on actual counsel. And the TCPA, I've heard you say this before, but it's like a living and breathing thing with all these court cases and everything. You can't check on it once and then just forget about it, right?
Right. Well, okay. I mean, this case came out, a week ago. We've covered cases that came out 2 weeks ago. The DC Circuit issued a landmark ruling 2 weeks ago. So it is a living and breathing thing. The FCC got reversed in that DC Circuit case on 2 pillars of TCPA law. So we're going to essentially go back to scratch on a couple of major issues. So whatever advice you got 2-3 years ago probably isn't terribly good anymore, and you're definitely going to want to keep that fresh. And even if the advice is still good, the law can differ in material respects and in subtle ways across the country. So depending on where you are and where your campaigns are focused, the case law in the Second Circuit, in the New York, New Jersey area is not the same in some key TCPA respects as the 11th Circuit, which covers Florida and Georgia and parts of the Southeast. So you want to make sure that you're really getting sensitive, advice that's really, really keyed in on your risk analysis and risk tolerance about, how aggressive you want to be or how conservative you want to be.
So in summary, your campaigns. YouTube videos are not the be-all, end-all.
No. This is high level. We're talking about this case.
Yeah, exactly.
Whatever's public, right?
All right, sounds good. Well, again, my name is Derek Johnson with Tatango.com. We are here with Joe Bowser from the TCPA Defense Force, which is part of Innovista Law. Definitely check out their website. They have some great resources. Sign up for their blog. It's always updated. It's extremely relevant information for TCPA stuff. And as always, if you're interested in text message marketing, look for a third-party TCPA attorney to really help you kind of guide you through all these things. Again, thanks, Joe, for stopping by and helping us review this case.
Thanks so much, Derek. I got too much sun yesterday, but I am blushing. So thank you for the kind words.
Sounds good. Talk to everybody soon. Bye.
Thanks, everybody.